Yeah, Bill.
Or can you just explain a little bit more what the basis of the challenge is in this particular case?
Well, okay, it's based upon the same analysis, basic analysis I gave you of how a court approaches the Constitution. It's a denial of equal protection under the law, under the 14th Amendment, which is that no state can deny its citizens equal protection of law. It's the view that the right to marry is a fundamental right, and that homosexuality is a suspect classification, and that and Bill was going to be a witness, by the way. We spent hours on the phone getting Bill ready to testify. That the pro Prop 8 campaign was based on an animus against gays. The only reason you do this is because you don't like, you hate gays, and therefore you just want to make sure. You have to understand, and you should go online. You can go online and read these documents. Incredibly skilled attorneys for the plaintiffs in this case, and they just start with the assumption that, hey, everybody's the same, and this is just, I mean, you guys, what's your hang up about this? Obviously, it can't mean procreation. Lots of people marry who can't procreate, and all you're doing is just, nothing's going to be taken away from you. Nothing's going to be taken away from heterosexual couples, and therefore you just have an animus against an ancient animus against homosexuals, and you want to reserve that last little shred to show that you're better than them. That's the argument, and that's the way it's proceeding. Does that answer your question, though?
Yeah, so it's sort of a combination of this. I mean, it is a challenge under the federal constitution.
Correct.
Right, that it violates. That's the whole
right.
basis.
The 14th Amendment.
I didn't understand the business of animus, and I find it very strange because you explained in some sense that this actually has a background in Colorado.
Well, I'm not familiar. I haven't. Mea culpa. I did not do my homework. I should have reread Roma before I came tonight, but I did not. This is where animus comes in, and as I say, you have to be careful how far we get in the weeds. But this is how animus comes in. I can have a law that is facially neutral on its face, and that's the best place to be facially neutral, your face, but has what's known in the law as disparate impact. And actually, this is the argument that Marvin Baxter used about this case. I mean, the Court of Appeal, by the way, Intermediate Court of Appeal, overruled the trial court in the case against Prop 22, in remarriage cases. The trial court had ruled that it was a violation of the Constitution. The Court of Appeal on a 2-to-1 ruling said no, it wasn't. And here's one of the reasons. This could be characterized as not a case at all of separate classifications of people. All this says is a man marries a woman and a woman marries a man. It doesn't say homosexuals can't marry. It just says a man marries a woman and a woman marries a man. So a homosexual male is free to marry any woman he wants to. Any woman will have him. Doesn't lock anybody out of that. Okay. It may have what's known as a disparate impact because, generally speaking, the reason you're a homosexual is you're not sexually attracted to a woman, and therefore you would not generally want to be entering into a marriage with her. In that case of disparate impact, the general rule is, in order to overturn that statute, you have to show that it was motivated by animus. In other words, that it was pretextual. What you really were doing was very cleverly writing the law to get at somebody without looking like it. And that's why it was important that the California State Supreme Court in the in-re marriage cases where they did overturn Prop 22 said that Prop 22 was not passed for an improper motive. And it's a show. I mean, these are show trials. I mean, just think about this for a second. We're talking about marriage. And we're going to solve this problem in 2 weeks with 15 witnesses? Under the rules of evidence? Which means, you know, you can only... And then some wise judge who's appointed for life is going to sit back and say, well, in my opinion, huh? I mean, it's just a very strange way to go about things, right? I mean, what if the attorney cross-examining the expert witness has an off day? What if one of the witnesses gets sick and can't show? What if they get nervous under the stand and don't give their best testimony? Does that mean that you and I have to live with that and what marriage is in California changes? I mean, it's a very strange way to approach. Now, let me give you an example of where expert witnesses are important. Let's assume we have a fire case. Can you hear me?
No.
The battery might have worn out.
Oh, okay. Can you hear me?
Yes.
Okay, so irrespective of a worn out battery. Let's assume you have a case where the question between two parties is who started a fire. I think you started a fire negligently and it burned down my place of business. I got one of these cases, right? You burned down my place of business and you owe me damages. Okay, we go to court. We will have experts. My expert will say, Bill started the fire and this is how and this is why. And your expert will say, no, I didn't, and here's how and here's why. And you have a discrete question where two people will give their reasons, and a trier of fact, be it judge or jury, will have to decide which of the experts they believe. Now, does that mean that the right thing will always be done? No. But the two things. Number one, it is an area that is subject to that kind of analysis. And secondly, and this is one of the big things in the law, what's your alternative? 6 guns at high noon to resolve the dispute? You got to resolve the dispute somehow, and we've found over a period of time that this is probably a better way than just, putting a coal in somebody's hand or dunk them in a pool or whatnot. We try to do it the best way we can. There's no necessity at all to determine what marriage should be, to put it in a courtroom and have it out this way. There's a name for it. It's called usurpation, in my opinion. It's usurpation of the powers of the people. Now, people would come back and say, yes, Mr. Pierucci, but what about Brown versus Board of Education? And I would say to them, what about the Brown versus Education? Wasn't done the same way? Well, there was a sense in which it was. And it was also a matter in the lived experience of our people. There was a little thing called the Civil War where we settled this matter, and we had an aberrational decision of Plessy versus Ferguson that separate but equal was okay. And it didn't actually take, in my humble opinion, one expert witness to say that shouldn't be the law in the United States of America as a matter of principle. Because why? Because race and gender are different. We're not talking about marriages. We're talking about, shall we in this country treat people who are African American the same as white? We solved that problem with about 600,000 dead. So, I mean, it's just not in no way analogous, in my opinion. Yes, sir. One more for you, and then if...
I'm going to take a wild guess, Ernest, that Antonin Scalia, although he is a judge, is not a member of the class you've been calling the judicial class.
Correct.
While Judge Vaughn, also a judge, is a member of the class you've been calling the judicial class. And I'll go further. As a professor, I am not a member of the class that you assign Ms. Cott to, called the academic class. So what I'd like you to do is define the judicial and academic classes for us so that we know who it is we will have to contest with the rest of our citizens.